To everyone attending. We are delighted to have Mr. Gopal Subramanium and our Vice Chancellor Faizan Mustafa sir. We are thankful to Faizan sir for helping us coordinate with this webinar. And I would invite Faizan sir to welcome Mr. Gopal Subramaniam with us.
Yeah, it gives me great pleasure and I feel honored in welcoming Mr. Gopal Subramaniam, whom I know for many, many years. In fact, of all the senior lawyers I know, he is probably the most humane one. As the listeners of this webinar are aware that he became senior advocate at a very young age. It was a so motive initiative of Supreme Court. I have spent a lot of time with Mr. Subramaniam. He was arguing for Government of India as Solicitor General in the Aligarh Muslim University case. We have traveled together in train and also in flights, and the kind of arguments, long arguments for hours together he has made during the preparation. Also, I have spent a lot of time, but what really left a lasting impact on me, that he was very, very generous with the attendants who were accompanying me from Aligarh Muslim University. And each time his tip was 5,000 rupees for each one of them. And whenever I go to Aligarh off and on, these people come to me and they don't ask me anything about myself. How are you? They will ask, Sir, kaise? So he was really very, very affectionate. I believe that when there were problems created in his very well-deserved elevation, he was very quick, like the most ethical person, to quickly withdraw his consent. But in the process, it was entirely the loss of the court and the loss of the citizens. He has argued almost all leading cases of last 20-25 years. Uh, he resigned from his position of Solicitor General when Government of India engaged a private lawyer, and that's how, you know, the senior leaders of bar have been doing. I'm also aware as BCI chairman, he was probably the only chairman of BCI who took active interest in the affairs of legal education and tried to bring in third generation reforms in national law universities. Sir, I have been trying to get you to Nalsar physically, but that has not happened. But I'm very happy and glad that you have accepted our very kind invitation and honored us with your presence. I'm sure that this topic of constitution and labor law and the way number of states are reforming labor just to bring in more investment, uh, even though it has not been proved in any empirical authentic research that if you have weak labor laws, the capital and investment will come to you. It has not been proved anywhere. Uh, Many constitutional issues are involved. Some states have not even bothered to go to President of India, even though you have central laws which they are trying to amend that too through an ordinance. So at a time when we are having the migrant crisis, at a time when our economy is in red, uh, we are reforming labor laws and we are taking away the guarantees which have been made available to workers after long, long struggle of labor. There is no better person who can speak on labor law and constitution. Sir, I once again welcome you and want to really express my gratitude on behalf of my students and faculty. And I also want to extend and extend an invitation to you that you should physically visit Nalsar sometime. I can assure you that not only Nalsar is A++ institution as per NAC, but it is a really liberating and democratic space. And very few universities in India can really claim to be such a space. Thank you very much, sir.
Dr. Mustafa, it is such a pleasure to hear your voice. And even though I'm not meeting you physically, but I'm seeing you in the virtual world. And I do remember our very, very friendly, and if I may say so, deeply academic-oriented association. I also know how you functioned in the Aligarh Muslim University with such devotion, then as Vice-Chancellor at KIIT in Bhubaneswar. And I was delighted to know that you are now the Vice-Chancellor at Nalsar, where one of my very eminent and distinguished seniors, who after retirement used to teach there, Mr. Vepa Sarathi.
Yes.
He was like a father figure to me, and I do remember him very, very fondly. So in some context or the other, Nalsar is linked in my mind with Mr. Sarathi. And I'm very grateful to you for your kind words, and I will certainly make it a point to accept the invitation when the sky is clear and to visit the institution myself. The topic which is there for our consideration today is a very relevant topic, not one of easy, straightforward answers, but requires some degree of insight. And that is labor and our constitution. What do we mean by labor? I'll come to this question a little later. It is a matter of universal agreement that all human beings have equal moral worth. At the same time, despite the fact that human civilization has never been more prosperous and sometimes even alive to injustice, acute economic inequality is a persistent feature of nearly every country in the earth. In other words, inequality exists. There is a view of certain economists, and I speak amongst them one of the most distinguished economists of the United States, Dr. Thomas Sowell, who believes that in the very nature of things, having regard to geography, the strata of society, the incomes, opportunities, some kind of inequality is inherent. So we must also know that situational idealism or equality is never presented by itself, but we are striving towards it. And what does it mean in the Indian context is a very necessary question. In a preliminary assessment made in March this year, the International Labour Organization had said that COVID-19 will have serious disruptive effects, which may leave some 24.7 million people unemployed. It is a critical time to pay attention to the lot of Indian citizens who are members of a workforce at present. So when I use the word labor, I mean those who are a part of a workforce. There are important normative grounds for us to pay attention to the consequences of radical disparities in income and wealth. As inheritors of our constitution, there are two reasons why we should be concerned with the vast number of working class citizens. One must be alive that incomes are intended to be fair in the sense of commensurability, which is the focus of labor economics. First, the entire thrust of the Constitution is empowerment. A deep commitment to uplift is in our Constitution's very texture, in the text as well as the spirit. The telos of Part 3 and 4, and indeed of human rights everywhere, is to speak on behalf of the disempowered and to make the moral imperative that we all have dedication to the preservation of the dignity of the disempowered, which is clear and binding in law. However, how to actualize it, that is the challenge. To begin on this project of giving people the power, the first step is to acknowledge not only that debilitating asymmetries of power exist in India, but also to seek out the source of these asymmetries. It cannot be disputed that the way in which capital, which is the means of production, is held is a maker of economic power. It has been apparent since the Industrial Revolution, which began in the late 1700s in England, when the first factories began to be set up, that the relation between factory owners and workers is one marked by great asymmetries of power. In practice, the very access to a livelihood for the vast majority of mankind is determined by the employers. As a consequence, there is a certain degree of control which employers have in order to afford dignity translatable in terms of food, shelter, and health. Regulating this power could be a constitutional preoccupation, particularly in extraordinary circumstances. Sir Otto Kahn-Freund, the comparativist and scholar of labor law, was of the opinion that labor laws are means by which to rein in and control the social power of those who own the means of production. He explained the idea of social powers in the following terms: the power to make policy, to make rules, and to make decisions, and to ensure that these are obeyed is a social power. It rests on many foundations: on wealth, on personal prestige, on tradition, sometimes on physical force, often on sheer inertia. Labor law, he said, is chiefly concerned with this elementary phenomenon of social power. This preoccupation with addressing unequal power was a primary consideration which weighed with Dr. B.R. Ambedkar, whom I personally believe is a thinker who would rank alongside both Bertrand Russell and Karl Marx for the sheer depth of his knowledge and vast degree of insight and understanding of multiple disciplines. He happens to be not only a great lawyer, a great economist, a great anthropologist, and a great sociologist, all rolled into one. I would always advise the students of the National Law School that if they have some time during this period, they must visit a website of the Government of India, which has published the complete works of Dr. Ambedkar. They are in multiple volumes. I think there are about 17 volumes, and I would be very happy if some time is spent in reading them. What struck me in reading those volumes was very insightful prefaces and foreword written by one Mr. Kabam, a minister in the Maharashtra government, absolutely elegantly praised on Dr. Ambedkar's contribution in each volume. This preoccupation of inequality weighed with Dr. Ambedkar. Dr. Ambedkar wanted to determine how was inequality arising in Indian society. He found that inequality arose substantially on account of economic and social backwardness. The economic and social backwardness is what has led, shall we say, to the theory of affirmative action, which has in its base scheduled castes, scheduled tribes, and other backward classes. The fact does remain that the initial analysis by Dr. Ambedkar, based on his understanding of caste and what he explains in the first volume, what does really caste mean, and what is the relevance of speaking about the subject, is he makes a direct connection between caste as well as inequality. And that is something which we must understand was a foundational basis. He was also aware, very interestingly, about the conflicts which happen even in industrialization. He was aware that there was a possible traction, a conflict which could happen between capital and labor. We must not forget that as far as Karl Marx himself was concerned, he had an opportunity to study how capitalism worked in America. This is a little significant, as you will shortly see. Madison, who was one of the framers of the American Constitution, who in Federalist number 10 had discussed the theory of utilitarianism and the effort on the part of groups and classes to maximize their own position and self-interest. And, however, the way it was actually played out was that there would be a free market or free trade, free market really, free trade has a different connotation, which was actually a capitalist society. Marx noticed in that very society that it was not able to discover the value of human capital, which is labor. Labor is equal to human capital in contradistinction to what we call as wealth capital. So this is an important consideration to be kept in mind. Now, Dr. Ambedkar, in the subcommittee which framed the draft constitution, mentioned that fundamental rights had to be included in India's constitution so that the possibility of the more powerful having the power to impose arbitrary restraint on the less powerful by withdrawing from the control he has over the economic life of the people must be eliminated. Democracy is predicated on the moral as well as the practical force of the idea of the quality of every human being, whether a man or a woman. This equality supports the freedom of all to participate and have a fair say in the life of the Republic. Equal dignity and equal treatment are bedrocks of democratic life. In a radically unequal society, these guarantees tend to weaken. Liberal democratic institutions are concerned with ensuring the longevity of these guarantees of dignity and equality. They do so by means of human rights, such as those contained in Part 3. However, some argue that this normative system is distinct from the one which operates in relation to workers' rights. Such a view mistakes the nature of both human rights as well as labor rights. In fact, the Universal Declaration of Human Rights, which was the basis of our Constitution, as observed by Chief Justice Sikri in Keshavananda Bharati's case, expressly noted the rights of workers in provisions such as Articles 23 and 24. Article 23 said, everyone has the right to work, to free choice of employment, to just and favorable conditions of work, and to protection against unemployment. Everyone, without any discrimination, has the right to equal pay for equal work. Everyone who works has the right to just and favorable remuneration, ensuring for himself and his family an existence worthy of human dignity, and supplemented if necessary by other means of social protection. Everyone has the right to form and to join trade unions for the protection of his interests. Article 24 said, everyone has the right to rest and leisure, including reasonable limitation of working hours and periodic holidays with pay. The enforceable companion to the UDHR is the International Covenant on Economic, Social, and Cultural Rights, which came into force in 1976, which also provided for a right to fair wages and to leisure, to safe working conditions, and to non-discriminatory treatment in matters of promotion in Article 7. Article 7 read, the states parties to the present covenant recognize the right of everyone to the enjoyment of just and favorable conditions of work, which ensure in particular a remuneration which provides all workers as a minimum with fair wages and equal remuneration for work of equal value. This is important, equal value, without distinction of any kind, in particular, women being guaranteed conditions of work not inferior to those enjoyed by men, with equal pay for equal work. A decent living for themselves and their families in accordance with the provisions of the present covenant, safe and healthy working conditions, equal opportunity for everyone to be promoted in his employment to an appropriate higher level, subject to no considerations other than those of seniority and competence, rest, leisure, and reasonable holidays with pay, as well as remuneration for public holidays. Ours is the only constitution which has very special articles in respect of people who belong to the working class. It is a unique constitution. In some sense, it can be said that if Marxian theory was actually a tool, even if it was not a complete economic solution, but was a graphic tool to understand income inequality, then certainly the Indian Constitution contains certain provisions to recognize that perception. That is in Article 38.2, which is under Part 4, that is Directive Principles of State Policy. Article 38.2 reads, the state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. The power of the collective emanates from the freedom of association. As Justice Chandrachud has said in his very learned judgment in Puttaswamy, human rights are built on a foundation that focuses on giving the individual full moral and legal regard. In relation to the Minimum Wages Act, which predates the Constitution, in the case of Mamarde versus Authority under the Minimum Wages Act, Justice Dua observed, the act which was enacted in 1948 has its roots in the recommendation adopted by the International Labour Conference in 1928. The object of the act, as stated in the preamble, is to provide for fixing minimum rates of wages in certain employments. And this seems to us to be clearly directed against exploitation of the ignorant, less organized, and less privileged members of the society by the capitalist class. this is an expression in the Supreme Court judgment. This anxiety on the part of the society for improving the general economic condition of some of its less favored members appears to be in supersession of the old principle of absolute freedom of contract and the doctrine of laissez-faire, and in recognition of the new principles of and common good. Prior to our constitution, this principle was advocated by the movement for liberal employment in civilized countries, and the act, which is a pre-constitution measure, was the offspring of that movement. Under our present constitution, the state is now expressly directed to endeavor to secure to all workers, whether agricultural, industrial, or otherwise, not only bare physical subsistence, but a living wage and conditions of work, ensuring a decent standard of life and full enjoyment of leisure. This directive principle of state policy, being conducive to the general interest of public and therefore to the healthy progress of the nation as a whole, merely lays down the foundation for appropriate social structures in which the labor will find its place of dignity, legitimately due to it in lieu of its contribution to the progress of national economic prosperity. The Act has, since its enactment, been amended on several occasions, apparently to make it more and more effective in achieving its object, which has since secured more firm support from the Constitution. The protection of workers' rights through the means of the Constitution was undoubtedly intended by the framers. As early as in the 1920s, at a time when constitutional rights were thought of as being limited to those rights which cast duties of non-interference by the state, the Motilal Nehru report in 1928 called for positive state obligations to realize economic justice and protect workers' rights. Its recommended Article 4 imposed a duty to legislate towards realizing workers' rights, which reads as follows. Article 4. Parliament shall make suitable laws for the maintenance of health and fitness for work of all citizens, securing of a living wage for every worker, the protection of motherhood, welfare of children, and the economic consequences of old age, infirmity, and unemployment. And Parliament shall also make laws to ensure fair rent and fixity and permanence of tenure to agricultural tenants. There is a great deal of emerging scholarship at the intersection of law and political economy, which critiques neoliberalism that has crept into the even field of law. Before I come to some of the latest studies, I want to say, broadly speaking, that we have four important schools of thought which are to be considered. One is a Marxist school of thought, typified by somebody like Professor West at Harvard. The second is we have constitutional economics, typified by John Buchanan, and to some extent by Professor Sen. The third is we have the concept of freedom of business beyond borders and without restraints by the state, so that there could be greater access to development. Again, one of the world's greatest scholars, Professor Jagdish Bhagwati. And we have in the fourth, a slightly more involved structure, which looks at, shall we say, a mix and match solution in the light of changing circumstances in the world or the globe. So we have different approaches, and labor economics is also actually, that should be the fourth one, which looks at very, very accurate mining of data and analyzes data very, very thoroughly, and then comes to very important conclusions. We have Professor Paul Haber. He is one of the leading scholars at Princeton. Again, one of the people very distinguished in this field of labor economics. There is this important wealth of scholarship. In India, we have also Professor Prabhat Patnaik, and we have David Singh Garewal and Jadaya Purdi, who have also explained the contrast between and the incompatibility, shall we say, between market, which means free market, and neoliberal logic and democratic legitimacy in the following way, and I quote them. Neoliberal claims advance the market side of this contest in capitalist democracies between capitalist imperatives and democratic demands. The contest is persistent because of pressures that capitalist markets make on the legal and political order, pressures not just for familiar protections of property and contract, but also for a favorable return on investment in managerial authority, freedom to manage. Neoliberalism, like classical liberalism before it, is also associated with a kind of ideological expansionism in which market-modeled concepts of efficiency, autonomy, shape, policy, doctrine, and other discourses of legitimacy outside of traditionally economic areas. Democracy, however, makes its own demands, which can provide and which can prove incompatible with capitalist imperatives and hostile to the conceptions of personhood and politics that the latter imperatives entail. Democratic citizens tend to hold a set of expectations about economic and political life that may go beyond or even contradict market logic. For instance, a reasonable level of economic opportunity, distributive fairness, workplace security, community and solidarity, and civic equality. When pressed in politics, these popular expectations become candidates for criteria of democratic legitimacy. And we must not forget at this point of time that in the preamble of our Constitution, we use the word justice. We use the word justice, social, economic, political, and there is an element of distributive justice, which is also mentioned in Article 38 of the Constitution. One of the assumptions of capitalism and economic liberalization across the world has been the idea of a trickle-down effect. And one very eminent Marxist scholar in India observed, it used to be claimed at one time that the benefits of a rapid expansion of GDP would automatically trickle down to the poor, so that a high growth rate of GDP could very legitimately be looked upon as the summum bonum of the development effort. This claim, however, has been so obviously discredited that a few would make it now. However, we have a contrary point of view, that is from one of the greatest economists of this period. He is considered again to be an extraordinary writer, and if you do read his pieces, you will see his deep knowledge not only of economics but even of art and literature, Professor Jagdish Bhagwati. And it is again a matter of sheer coincidence that Justice P.N. Bhagwati, who later became the Chief Justice of India, was actually the brother of Professor Jagdish Bhagwati. And Professor Jagdish Bhagwati said, as the 20th century ended, capitalism seemed to have vanquished its rivals. Fascism, communism, and socialism. The disappearance of alternative models of development provoked anguished reactions from the old anti-capitalists of the post-war era, who ranged from socialists to revolutionaries and remained captive to a nostalgia for their vanished dreams. But globalization has also fallen afoul of a younger group of critics, and the nostalgia of the fading generation cannot compete with the passions of these younger dissidents who were so evident on the streets at recent World Economic gatherings in Seattle, Washington, Prague, Quebec City, and Geneva, and who have made themselves heard on college campuses in movements such as the Anti-Sweatshop Coalition. For too many of the young see capitalism as a system that cannot meaningfully address questions of social justice. Many of these youthful skeptics seem unaware that socialist planning in countries such as India, which replaced markets system-wide with quantitative allocations, worsened rather than improved unequal access. Such socialism produced cues that the well-connected and the well-endowed could jump, whereas markets allow a larger number of people to access their targets. Capitalism is a system that paradoxically can destroy privilege and open up economic opportunity to many, but this fact is lost on most of the system's vocal critics. Many of today's young, virulent, anti-capitalists experience their social awakenings on campuses in fields other than economics. This also reminds me of Sir Roger Scruton, one of Britain's leading philosophers, who also has spoken about people wanting to be highly judgmental, wanting to stand out of the system and make very critical comments about the system without actually knowing what it is to be inside the system. That's just an aside. I'm continuing with what Professor Bhagwati said. English, comparative literature, and sociology are all fertile breeding grounds for such dissent. Deconstructionism, as espoused by the French philosopher Jacques Derrida, has, with its advocacy of an endless horizon of meanings, left the typical student of literature without anchor. Derrida's technique is to deconstruct every political ideology, including Marxism. Typically, however, it is capitalism that becomes the focus of these efforts, not Marxism. And this process often has nihilistic overtones, with the paradoxical result that many of its followers now turn to anarchy. Within sociology, new literary theory and old Marxist thought have equal influence on many students. These students have contempt for economic defenses of capitalism, asserting that economics is about value, whereas sociology is about values. Economics retort that as citizens, they may choose ends, but as economists, they choose the means for harnessing humanity's basest instincts through appropriate institutional design to produce public good. This also brings us, in some sense, constitutional economics. The presumption made by many of its radical students that sociology is a better guide to ethics than is economics is also misplaced. Certainly, sociology's related discipline, social anthropology, many of whose adherents now find their voice in non-governmental organizations, foundations, and the World Bank traditionally leans toward preserving cultures, whereas economics is a tool for change. But if reducing poverty, and these are the four compelling lines, but if reducing poverty by using economic analysis to accelerate growth and thereby pull people up into gainful employment and dignified sustenance is not moral and a compelling imperative, what is? The counter-argument to the neoliberal approach has been made eloquently at a global scale by the deep and empirical scholarship of the French economist Thomas Piketty. I'm now coming back again. So first it was one view, I've given you another view, now again back to another view. And this view is presently gaining a lot of momentum, even in the United States. And there is this discussion about concentration of wealth. There is this discussion of what is called plutocracy. There is this discussion that the future generations would be inheritors of wealth for which they have never worked. There are these projections, and Thomas Piketty's work has drawn a great deal of praise from one of the Nobel Prize laureates, Paul Krugman, who has spoken very, very passionately about the depth of scholarship found in this particular book. Incidentally, I wanted to mention, since you saw Professor Jagdish Bhagwati's comments on how you interpret different disciplines through the lens of Marxism, there is a very interesting lecture. And if you can have access to it, I would encourage you to please look at that lecture. It is a lecture delivered by Ronald Dworkin. And this lecture was delivered at the Library of Congress. The subject is absolutely fascinating. The subject is interpretation of law, literature, and history. And it is a magnificent lecture. It is simply breathtaking. What Professor Dworkin says is that how do you know the truth about interpretation? Everyone asserts that this is the truth. One looks at it from one yana of interpretation, another looks at it from another yana of interpretation, a third one from a third yana of interpretation. So he gives the example of a poem written by William Butler Yeats, and that was Among School Children, a very lovely poem. And he speaks about the interpretation of that poem placed by one of the traditional scholars, critics, shall we say, F.R. Leavis. Then there's a second interpretation by Clement Brooks. Then he comes to what we call as an interpretation of Stoicism, where you are simply Stoic or skeptical. There's a skeptic's interpretation. Then the fourth is the interpretation which belongs to Coleridge. That is, it is the genius of the poet which is actually reflected. And it is that genius which we must be able to discern in the work of literature. This is a very interesting example. And then he comes to the position of law, that how would lawyers, two lawyers, actually use different tools of interpretation with reference to the same text. Whereas he said, in respect of history, it is more of an explanatory method of interpretation rather than attributive method, which exists both in law as well as in literature. I did mention it because when I was reading Professor Jagdish Bhagwati's extract, I was reminded of this wonderful lecture by Professor Dawkins. And it also tells you that how much he knew himself about literature. The one point which he finally made is that as critics or as interpreters, the rule which should be relevant is the rule of responsibility. And he also said, what you do is you join the tradition of other critics. It is not that you are actually away from them. You join that. And then he referred very interestingly to something which I have always admired as a kind of a mini scripture, which is an essay written by T.S. Eliot called Tradition and Individual Talent. T.S. Eliot argues that there's nothing called individual talent unless you have a connectivity with what is tradition, or awareness and knowledge of tradition. Now, in his 2020 book, Capital and Ideology, Piketty studies inequality in India alongside other states. His thesis is that the great driver of human progress over the centuries has been the struggle for equality and education, and not, as it is often assumed, the assertion of property rights or the pursuit of stability. In his earlier book, he had marshaled a great deal of data to make the case that capitalism can breed and perpetuate inequality. Susan Marx has also written about the same subject. Now, we have differing points of view. How do we actually proceed is a question. We have to proceed from some knowledge. We have to also proceed on the basis of the present situation. What is the knowledge from the past which we have? This is, I think, very important, and it should be critically discovered by all of you. What is the past? The past is we set out for a mission, a project of a welfare state. In that project of welfare state, we do accommodate very substantially various important segments of society in terms of fundamental rights, by way of affirmative action, and also in the directive principles of state policy. Although, as I mentioned to you, that caste and employment and income inequality were all intertwined with each other, because even the nature of employment, as was observed by Dr. Ambedkar, which later was reinforced by the Mandal Commission in its report, there was this belief that there is this stamp of poverty which places people at a position of considerable disadvantage. Now, we have moved on the belief that it is the state which is synonymous with public interest, public welfare, and the good for the poor. That belief structure had right through gone on, and as has been observed in again a very brilliant book by Mr. Arvind Panagaria on the liberalization which happened in India. He in fact points out that the liberalization had started commencing in small driblets even prior to 1991. And it is after 1991, of course, there was liberalization. What does liberalization mean? Does it mean we have become simply capitalist? Does it mean that we abandon the objectives of protection which are enshrined in the Constitution? Do we actually switch totally to another perspective? This is an important question. Or is it possible that there is a possibility of, because we have to find solutions. The problem with one school of thought, which can be a critical tool of analysis, is it may not still give you what you should assume are final solutions of equality. If final solutions cannot be printed on a drawing board, it is only a tool for the purpose of attributing what we call as value to labor. What is this tool? Let us talk about this at this point of time. The question which arose, and there is again a very interesting article, if any of you can research on it, which shows a dialogue which has taken place between three people. One is Aristotle, the second is Marx, the third is a Japanese economist, again, a man of great distinction, Yuko. The three of them seem to have a dialogue, and the question is, what was the attribution made by Marx to money, and what was his understanding of the value of labor vis-a-vis money? And he very subtly points out that Aristotle was unable to understand the full concept of value of labor. He was able to understand that there could be exchange of goods, and that was possible through a medium of equivalence called money, comparables, but he was unable to locate that what would be a component which would contribute to the value of the two products, which was labor. And perhaps he says rightly that because there was so much of slavery in Greece at the time that he couldn't think of this aspect very clearly. Marx, on the other hand, found that the element of labor was an important component in production, and he was interested in discovering whether it could be attributed a true value. In the process of discovering whether it could be attributed a true value, he came to the conclusion that there were interests with an interest with an interest with an interest. That is, one would be overloading the second, overloading the third, overloading the fourth, and so on and so forth. It is very interesting to know this, because this is clearly a great tool to realize that the asymmetry can be visible and is visible. We must not forget that all these articles in the Constitution cannot be abandoned or jettisoned or overlooked, because we are in a sudden state of utopia, or shall we say in ideal circumstances. At the same time, we have to look for solutions by which the people who are contributing as the working class are treated with dignity, fairness. Now, this fairness again is very interesting, because Madison again, and there is an American economist, I think he is Charles Beer, who brought this up in the context of Madison's Federalist number 10, that you have what are called the fair, just, and efficient outcomes. Interestingly, the fair, just, efficient outcomes, which inspired Madison and, shall we say, the economy of America, was the very same three factors which enabled Marx to find in them the possibility of a non-attribution of a true value to human capital. This human capital has to be correctly appraised. Is it that they're always in a state of conflict? I do not actually believe so. And this is where I believe that the way forward is a constructive way, by which I do believe that India can itself be a front runner in a new design. What is that new design which is possible? It is not some, shall I say, very loose mix and match. There must be some non-negotiable guarantees as far as the working class is concerned. There must be some way of assessing that there is no exploitation vis-a-vis the working class is concerned. Why? Because they do constitute, and particularly those who are in the informal sector, they constitute 90% of the population. 90% is, that is roughly about, we have almost 90% of the working class is the informal sector. And we have roughly 10 crores who belong to the informal sector. These are very huge numbers. And these numbers are substantial. They are a fundamental integral component of your population. At the same time, we must investigate that why, notwithstanding the existence of labor laws in our country, still people were excluded. This is very important for us to understand. Dr. Thomas Sowell says in his book on disparities and discrimination, he has studied the Indian reservations, by the way, and he says, all said and done, there was continuous extension of reservations, but empirical evidence suggests that actually those who were supposed to be benefited by the reservations never got the benefit of reservations, and they're also the more prosperous in those castes were the ones who were able to hold the reservations. That's a very important chapter. And he is an economist who goes on very hard evidence and does not say anything unless he has investigated clearly the data. This is a point because at some point of time, we will have to bring the efforts to include the working class on fundamental canons of dignity, and who better than the businesses in India or those who are entrepreneurs in India who would be able to offer that interface. This is a very important question. And here, I do not believe that in the interests of cost, in the interests of efficiency, there would be any loss. On the contrary, in the interests of costs and efficiency, there would be far better production, far better output, far greater collaboration, shall we say, by two forms of capital coming together. This is my design, if I may say so. This is a design which has also been thought of by others, but for the Indian condition, I think instead of leaving a segment of society, again, left to their own, shall we say, slow, meandering process of inclusion with upward mobility. And here, again, when we talk about investment, investment is again not a bad thing. Let us be very clear about it. Investment is not a pariah. You do need investment, you do need skills. The growth in most economies has happened because there has been an interplay of skills. So there are skills which can be brought by way of technology, by way of investment into India, which will benefit the process of development in India. But at the same time, we must see how should the fruits of that development trickle down, is where we must ensure that the minimum guarantees of dignity and protection are effectively reinstated for the working class. Now, therefore, I would urge for your consideration that since, and we must bear in mind, there is a fundamental right called Article 23. Article 23 forbids exploitation, big R. And therefore, as a matter of interpretation, since ours is a purposive and living constitution, alive to injustices and tailored to answering to it in the widest and most effective extent, we have to take care of the concerns of workers, the indignities which they have suffered, and particularly material deprivations which they have lived with in the context of the present lockdown. A powerful description of the project of upliftment which constitutions such as ours are committed to is reflected in an opinion rendered by Justice Albie Sachs in a very powerful dissent which he gave in 2005 as a judge of the South African Constitutional Court. He said that the purpose of constitutional law is to convert misfortune to be endured into injustice to be remedied. And I think it is an extremely telling and very apposite sentence to describe our situation. The Supreme Court held that the duties of assuring essential livelihood and physical dignity would be part of our socialist framework. By the 1980s, the court held that security of work was an important feature of a socialist republic. India is a socialist republic. It implies the existence of certain important obligations which the state has to discharge. The right to work, the right to free choice of employment, the right to just and favorable conditions of work, the right to protection against unemployment, the right of everyone who works to just and favorable remuneration, ensuring a decent living for himself and for family, the right of everyone without discrimination of any kind to equal pay for equal work, the right to rest, leisure, reasonable limitation on working hours and periodic holidays with pay, the right to form trade unions and the right to join trade unions of one's choice, and the right to security of work are some of the things which have to be ensured by appropriate legislative and executive measures. Of these rights, the question of security of work is of the utmost importance. To understand what does this concept of social and economic justice mean, for labor law, Justice Krishnaiah commended to us in the Bangalore water supply case his approach. And he said, in his inimitable style, law, especially industrial law, which regulates the rights and remedies of the working class, unfamiliar with the sophistications of definitions and shower of decisions, unable to secure expert legal opinion, what with poverty pricing them out of the justice market and denying them the staying power to withstand the multi-decked litigative process, de facto denies social justice if legal drafting is vagarious, definitions indefinite, and the court's rulings contradictory. Is it possible that the legislative chambers are too preoccupied with other pressing business to listen to court signals calling for clarification of ambiguous clauses? Now, the unorganized sector, as Professor Kamala Shankaran pointed out, both these international instruments dealing with the rights of those who work, as well as what Indian laws do exist, are focused almost exclusively on wage work. Of the Indian statutory scheme, in a very seminal article, she said, the protection afforded by labor law is not uniformly available to all those in wage employment, Labor law acts as an extraordinary force in several instances, notwithstanding attempts by the courts to liberally construe labor statutes, with the coverage of the laws restricted by the size of the establishment, functional and remunerative criteria, and a limited sector-wise coverage that leaves a large number of occupations and employments, typically in the unorganized sector, outside the reach of the law. So, for example, the vast majority of working Indians, such as domestic workers, work at the pleasure of their employers without employment contracts or any formal recognition in social security laws. Domestic workers and daily wage earners are examples of this class as well. I must incidentally point out that Justice Markandeya Kaju also has been very sensitive to the subject of both the conditions of the poor in terms of income inequality and also in terms of high rates of unemployment. And this is something which he has written about persistently. And what he points out is this is something which cannot be wished away. So any design in terms of constitutional economics will necessarily have to accommodate this particular segment. Some beneficial social security measures are contained in the Industrial Disputes Act. Well, you have some of them, like what is a layoff and so on and so forth. And then this also aligns with what is the National Disaster Management Act 2005, where there is a definition of the expression disaster. Under the Industrial Disputes Act, 50% of the basic wages and DNS allowance for working days has to be paid during which a worker has been laid off. In India, as per the National Sample Survey Office, even as of 2011-12, 92% of all workers are in the unorganized sector, where labor laws provide little or no safety net. As the French sociologist Robert Castel would put it, therefore, work is a factor of alienation, subordination, heteronomy, and even exploitation. Indeed, modern wage employment rests on the dialectic tension that connects those two dimensions. Work imposes constraints upon workers, while at the same time providing a pedestal that enables the worker to be recognized as such. The complex question of work and identity can also be approached with an anthropological lens. The connection between work and dignity and identity in India is apparent. The powerful phrase that labor is not a commodity is coined in the Declaration concerning the aims and purposes of the International Labour Organization, 1944, called the Philadelphia Declaration. The Supreme Court has vindicated the promise of Part 3 for the upliftment of the worker on numerous occasions. But the first signal achievement must be Bandhuva Mukti Moksha versus Union of India, authored by Chief Justice Bhagwati, in which rights which squarely accrue to stranded citizens and migrant workers were laid out. In that case, the Supreme Court made this express connection between human dignity and the right to demand from the government the provision of basic needs. The Supreme Court said, when a complaint is made on behalf of workmen that they are held in bondage and are working and living in miserable conditions without any proper or adequate shelter over their heads, without any protection against sun and rain, without 2 square meals per day, and only with dirty water to drink, it is difficult to appreciate how such a complaint can be thrown out on the ground that it is not violated of the fundamental right of the workman. And this is very important, fundamental right of the workman. This right to live with human dignity, enshrined in Article 21, derives its life breadth from the directive principles of state policy, and particularly clauses E and F of Article 39 and Articles 41 and 42. And at the least, therefore, it must include the protection of the health and the strength of workers, men and women, and of the tender age of children against abuse, opportunities and facilities for children to develop in a healthy manner and in conditions of freedom and dignity, educational facilities, just and humane conditions of work, and maternity relief. These are the minimum requirements which must exist in order to enable a person to live with human dignity, and no state, neither the central government nor any state government, has the right to take any action which will deprive a person of the enjoyment of these basic essentials. In Part 4, Article 39A provides that the citizens, men, women, equally have the right to an adequate means to livelihood, and B, ownership and control of material resources of the community are so distributed as best to subserve the common good. C, that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. Article 42, the state shall make provision for securing just and humane conditions of work and maternity relief. Article 43 calls on the state to endeavor to secure living wages and conditions of work that ensure a decent standard of life for all workers. And then all these are very significant. We have a large number of labor laws. We have the Bonded Labor System Abolition Act 76, Section 5 of Payment of Wages Act 36, Employees Compensation Act, which is again outdated, 1923, provisions of the Factories Act, and the Building and Other Construction Workers Act 1996. There are decisions of the Supreme Court which have spoken about the importance of livelihood. You're all familiar with the decision of the Supreme Court in Olga Tennis. In Article 23 is, of course, the injunction that there can be no traffic in human beings and begar, or any other similar form of forced labor, and any contravention of this provision shall be an offense punishable in accordance with law. Therefore, this is a very important aspect. To compel labor to work or to force them to work is indeed a matter which will attract Article 23 of the Constitution. To understand the Constitution's disposition to labor, in the People's Union for Democratic Rights, the court considered the import of the phrase bonded labor. This case is the authority for propositions of constitutional law that show the depth and strength of the constitutional protections afforded to workers. This was at the time when the athletes' village for the Asian Games in Delhi was to be constructed. The Supreme Court, again, Justice Bhagwati, said, "We do not think it would be right to place on the language of Article 23 an interpretation which would emasculate its beneficent provisions and defeat the very purpose of enacting them. We are clear of the view that Article 23 is intended to abolish every form of forced labor." Then the court proceeded to hold that the payment of wages less than the minimum wages would amount to forced labor. This was followed by giving an expansive definition to the word force, so that it included compulsion of economic circumstance, which takes away any freedom of choice in the matter of whether to work for insufficient pay. Both parts 3 and 4 recognize and empower workers to organize themselves and engage in collective bargaining to secure their interests. It also flows out of Article 19 and Article 43A. Recently, the Supreme Court on the 12th of June passed an order issuing certain interim measures for private establishments, industries, and employers to enter into negotiation and has also attempted to include the instruments of collective bargaining, namely trade unions and workers' associations. And these directions, namely to initiate a process to pay wages for 50 days, is indeed a welcome direction from the standpoint of the workers as well. In order to conclude, I think the need to be aware that many experiments of state being a promoter of public good have not exactly succeeded. But why? Does it not then call for a different design, which also achieves the same objects of part 3 and part 4? If you have laws, which are labor laws, but if they do not cover 90% of the workforce, or 92%, then what should be the regime by which their conditions are guaranteed? By doing this, are we in any way discouraging investment? Are we in any way discouraging business? Are we in any way compromising economic output? The answer to that will be clearly in the negative. I have to say two things. One is, as many economists have pointed out, that mobility in classes, in groups, is also concerned with the acquisition of skills. And the skills which people in the informal sector have, nobody else may have those skills. So it is necessary to value their contribution and that human capital which they have brought to bear in the economy. But they must be beset with minimum guarantees. The gaping holes, shall I say, in the entire social structure became evident when the COVID-19 lockdown had been imposed and when it was lifted. We noticed that there were a large number of people who were stranded. And of course, it is not that governments were not aware. Governments did, I assume, their best. Courts have also done their best. But it has brought to focus that there is this enormous mass of population who do need a voice in terms of constitutional economics, but at the same time, not as a disincentive or as a discouraging factor to discourage business or entrepreneurship, or for that matter of fact, investment. I would say that the requirement in the new design is what we call as a collaborative design. And it is a design which would need, again, a reworking, shall we say, of our own existing models, but very differently. So there can be no doctrinaire positions in all these issues. These are issues which also revolve and change with passage of time. Just as fiscal policies change in a country, so also economic policies will always need to be attuned to the requirements in a country. So while acknowledging that the economy needs to rise, it needs to come out of the kind of, shall we say, distortion which happened due to a virus, and that economy must again be running and must be moving along seamlessly, we must also pay attention to the rights of the labor. And the constitution then becomes, shall we say, the important instrument through which we are able to measure to some extent this collaboration. This collaboration is better measured through the objects which are enshrined in the Constitution. But objects which are mentioned in the Constitution have to be translated as realistic money rupee condition principles in the matter of labor. Lastly, there was some suggestion that government may appoint a commission, a national commission, to consider the situation in relation to people who are in the migrant section. But as I would say, it is a very important way forward, and it is also, I think, it would be a far-sighted effort if this initiative could bring about a new way of thinking. And this is an occasion where India, with its unique panoply and pluralistic skill sets all over the country, with mobility, as we have seen, from the north to the south and everywhere, it has got such a unique human capital that we must value it sufficiently to do it constitutional justice. Thank you very much. Please put it. Yeah.
Thank you so much, sir. It was a very enriching and informative session. Now I'd request if we move to the question and answer sessions, because quite a few people have asked some questions, and I'll be asking you the questions that have been posted during the course of the lecture. Thank you. Also, to all the attendees, due to paucity of time, we may not be able to take up all the questions, so I apologize in advance.
I don't mind. Take up as many as you like. I wouldn't get a chance to talk to you all very soon. So.
Okay, sir, then. Sure. So the first question that has come across is, if there are any lessons from the present coronavirus crisis, about the legislative and constitutional reforms? And if so, what shape should such reforms take so that the protections cannot be diluted in an ad hoc manner, as we have recently seen?
Well, as far as constitutional reforms are concerned, I don't think any constitutional reforms are needed. The Constitution is very clear, very, very sound. It has been a work of art, and it has given a lot of. There's a lot of substance in all the articles of the Constitution. What is important in the lessons is that we have to have a framework of laws, because without a law, how do you give security? Law is not to punish. Law is also a means of comfort. And by giving comfort, and again, this is again, if we look at the purpose of a law which is meant to be designed to give comfort for working classes in the labor, it should be very welcome. And I think it is needed. The belief that because there are establishments where these laws, where all these laws should be suspended out of the blue, that I think needs a revisitation, because these laws themselves are designed to protect. So, in fact, you have to look at it holistically. If you want to make a blueprint, you should make a different blueprint, but which also recognizes and achieves the same objectives.
So another question is that what is the position about rights of employees who have been fired or laid off due to this crisis, vis-a-vis the concerns of small employers who have not been able to pay the salaries of the employees and had to lay them off?
Well, we will have to see what is the position in relation to them. And this is what exactly Professor Shankar has said. Are these establishments covered in terms of size under the labor law? Or we will have to find what I think as ad hoc reconciliatory measures. It doesn't have to be through a conciliation officer. I think the government itself can design, shall we say, in order to see that there is a redressal mechanism to deal with what has happened during the COVID crisis. Because all people may not be members of a trade union who would be espousing their cause. There would be individual employees in a small establishment. So we must have some points of connect, which I think the government can certainly consider. And these could be useful points of connect to bring about the state of some payment to the workers so that there is an element of fairness in the outcome.
So another question is from our professor. He teaches at Nalsar, Vakishan sir. His question is, why is the Interstate Migrant Workers Act of 1979 breached more than it is implemented? And how would you look at it as a legal practitioner?
Well, I think the actual practice, the implementation of that act has been absolutely tardy. And I think it is not the fault of one executive government. I think this has been something which has been for a long time overlooked, that this act was never efficiently operated. And that is why there is this, this is what is also very important to bear in mind. Sometimes to look at working class as a cross around your neck is the wrong approach, which many times even governments tend to do. That this is they have to be managed. There's a containment strategy which is to be in place. Whereas if they actually had implemented that law effectively, there would have been more accountability. More accountability.
Someone asks how the change in government and their ideology affects the policy on labor laws. And do you see any shift in labor law policy with the change in governments?
Can you repeat the question, please, if you don't mind?
Yes, sir. How the change in government and their ideology affects the policy on labor laws. And do you see any shift in labor law policy in India with the change in government?
I have not actually seen that in reality. There has been no major shift. We've had liberalization, but we've not dispensed with the requirements under labor laws now. We've not done that. And so there has been some continuing pattern also in the economic models as well, shall we say. So there is some continuum. The political parties may be different, governments may be different, but there has been some continuum.
Despite the existence of a framework for labor in the Constitution, why is that the labor legislations are being consistently diluted with scant regard for security and welfare of working class? And why is there a gap between the organized and unorganized sector still so widely open?
I think this is where law has to step in. I think this is where law has to step in a manner that it facilitates, and actually it may be equally beneficial to the employer. I am thinking of a law which will be beneficial to both. It will be very transparent for the employer, and it will be very transparent even for the working class. It is possible. But law will have to step in.
When they said that there is equal opportunities and it should be given to all the laborers, What about the laborers who have disabilities? Like, what are the reforms that can be done for the laborers who have disabilities?
This needs attention. I mean, I think this needs a lot of attention, and particularly in the context of people who have disabilities. They have to be cared for. And as I said, that there is a lot of classification and sub-classification which is to be done when we take up this project in the form of either a study or in the form of reforms which are intended. Reforms must be progressive in character. They must take note of current realities. And we must also understand one thing, that the mental health of the working classes is equally important for this country. It is a very important condition to be respected. And what they must have gone through must have seriously impaired their condition. There has been a considerable amount of evidence in many countries that in COVID-19 during this period, it did have impact on even people who didn't have problems like mobility from their place of work to their place of residence. But even then, there has been cognitive impairment. So we have to understand with great compassion and respect out of the Constitution that when the Constitution uses the words humane, it truly means it. And we have to therefore understand that unless and until they feel that they have been addressed, it is important that they should not feel mentally disturbed at any stage. So assurances, calm, rational conversation, communication, dialogical structure, and as I said, on both sides coming together, this is very necessary. This is the unique moment in a nation's history where you don't actually follow repeat patterns of your old behavior. This calls for a new communication. And communication in times of distress is very different from communication in normal times.
Sir, another question is, in these COVID times when work from home is very prevalent, people are being forced to take paid leaves, and people do not have fixed working hours. They are working overtime. Since they're working from home, they're expected to work more. So is there any sort of redress that these people could have, or what is the scenario about this particular crisis?
Well, I can't make a generalized comment. It depends from place to place, situation to situation, institution to institution. Healthcare workers may be having to work more because of the number of patients they have to attend in a hospital. So it could be from a situation to situation, it could differ.
Another question is on the impact of the commissions, which says that how far have the commissions that have been set up by governments have been impactful, and are these recommendations have really helped in our legislation or executive?
This needs, I think, a more insightful study. As I said, you see, doctrinaire approaches are very different, shall we say, from actual data-driven approaches. Now, I have already given you some idea of what are all the different doctrinal approaches. I think the data-driven approach is very necessary. We need to have, and a lot of work has been done by activists in the sector. The kind of work which they have done is quite remarkable. If you see some of the reports of, for instance, in India exclusion, if you see that, you will find an idea. A lot of analysis has been done. So we could get data, we must study data calmly, and we must evolve possibly a policy. Even if not a law, there should be clearly a policy, which is enforced.
I feel we have covered basic themes of all the questions asked, since most of the questions that I've asked are in the context of COVID-19. So I would like to thank you, sir. Thank you so much. It was a great session. And I, on behalf of the lecture series on constitutionalism, would thank you for gracing us with your presence and enriching us with your knowledge. It was a very informative session. And
It was
we
a great
hope...
honor and privilege to address all of you. You are all the future of the legal profession. Law is in very safe hands, and I do expect that all of you will respect institutions. You know, these are the institutions are meant to be respected, but at the same time, we must have freedom of speech and expression within ourselves, but it must be for a constructive end. And the important thing is positivism. It is very easy to fall into criticism which doesn't serve a purpose. You must always think of solutions, and it should be solution-oriented positivism. And that is something which I'm sure all of you in Nalsar, I've had many former juniors in my chambers who studied at Nalsar. They're all very accomplished lawyers now. And I'm very proud of the way they are conducting and acquitting themselves in the legal profession. So thank you very much.
Thank you so much, sir. We hope that we are able to host you physically on campus sometime soon. It will be a dream.
Thank you.
Thank you so much, sir. Thank you.